Hi folks, and welcome back to Conveyancing. This week's topic is real estate agents. This week's topic follows on quite nicely from the topic in week one, which dealt with solicitors and their ethical duties. This week, looking at real estate agents, some of the material we have today also deals with ethical matters. So it's a logical flow on from week one. The first place to start really is the appointment of the agent, because that is where all of the rights and liabilities flow from. So let's look now at appointment of agents. So the relevant legislation in Queensland that deals with appointing agents is the Property Occupations Act, and you'll get to know this legislation fairly well by the end of this unit. It proscribes Form 6 as the relevant form to use. So the agent must be very, very scrupulous when they're filling out this little beastie. Uh, if they don't, they could find themselves in all sorts of hot water, not the least of which being failure to be able to claim commission. So here it is. You can see part one just deals with client details. Part two is your licensee. Part three, details of your property. Part four deals with appointment of your agent. Now, the form goes into much more detail in terms of the type of appointment over the page. So let's have a little look over the page. There you'll see part 6, property sales, open listing, sole agency or exclusive agency. And this is where many agents have come to grief, principally because they just don't explain the form to the client. So what they must do at the time that they're concluding this agreement with the seller is they must sit down with them and go through exactly what each type of agency means for the seller, when commission will be triggered under each type of agency, and failure to do so will inevitably, unfortunately, many times, like in the Ebfest case, involve some unnecessary money being expended in legal proceedings, because the seller will want to get out of paying the agent's commission on the basis that they haven't been properly appointed. So very, very important for the agent to get this bit right. The other part that seems to cause some grief is the clarity of the commission that's specified in Part 7. So if you're acting for a seller, you need to get your hands on a copy of the appointment of agent and just go through that to make sure that it's all been done correctly. Termination of appointment, you can see up there in Part 5. We will go through termination and how it bites on each of the different types of agency in just a moment. So I just thought you'd be interested to see what one of these little beasties looks like in real life. The last part of the form includes a warning, which I like to think of as having Lord Denning's big red hand there, waggly finger to the client saying you must secure independent legal advice before you sign off here. If you don't, you're at your own peril, basically. Section 104 of the Property Occupations Act requires that warning to be in there. I don't know of anybody that actually does get independent legal advice before signing the form. Not sure that it really achieves what it's intended to achieve, but at least if things fall apart and the appointment goes pear-shaped, at least the seller has been warned that this is a serious legal document that they're entering into that creates legal rights, and if they haven't got legal advice, well, they've done so at their own risk. So that is the Form 6. Nice to see one of those little beasties in action. The next thing to look at is the type of agency. As I said, this confuses a lot of people, and it's the point of contention in a number of different cases. The Ebfest case, certainly. And part of the reason I think is for some difficulty with the terminology. To the average Joe, using the word sole means you've appointed like one agent. Using the word exclusive kind of also seems to mean to the average Joe that you've appointed one agent. So I think that's where part of the problem comes from, and so it's important for you guys to get all of this stuff really clear in your heads. The first kind of appointment is the open appointment, and that basically means that you can retain the right to sell a house yourself. and you can appoint as many agents as you want. And you'll often see, houses that have been on the market for a while, and they might have had an exclusive agent to start with, and then that agency has expired, and then they've kind of engaged multiple other agents to try and offload this lemon. This is the way that you do it. You do it as an open agency. It does mean that the agents get quite competitive, and sometimes they can get a little bit cranky with the way that the other agents are working in with them. I have sold my house on an open listing, and it can be a bit of a nightmare coordinating the open houses from one agency to another. And, as I said, they can get a little bit annoyed. I had one agent complain to me that trying to sell a house on an open listing was rather like trying to sell something in a public toilet. There's that many people going in and out and so many agents. But nevertheless, as I said, it is good for the seller in the sense of if they want to get rid of the property quickly, they can have basically a team of agents working on that property for them. The good thing is that the seller will only have to pay commission to an agent if they are the effective cause of the sale, and that's something we'll look at in a little bit more detail in a minute. As to cancelling, you can cancel at any time in writing. So that's the open listing. The other kind of appointment is the sole agent, and this is probably the one that causes a lot of confusion. What happens under a sole agency is that you as seller, you as the owner of the property, retain the right to sell the property yourself, and you only appoint one other agent, okay? If the agent sells the property, they're going to be entitled to commission. If you as the owner are the effective cause of sale, then you do not need to pay that agent commission. Okay, as I said before, we'll talk about effective cause of sale later. Maximum term for a sole agency is 90 days, and cancelling is a little bit more of a tricky affair. If the term is more than 60 days, then you may terminate with 30 days written notice. Now, there's a minimum appointment for 60 days. So effectively what it means is that if you appoint a sole agent and you're sick and tired of them, you can actually go ahead and terminate after 30 days by written notice, and then that 30 days notice will take effect after the 60 days. So effectively your appointment is going to be for 60 days anyway, whether you like it or not. If it hasn't been terminated, then 90 days is the maximum that you can have for a sole agency. It's going to expire at the 90-day mark. So the next type is the exclusive agency, and this is for every real estate agent the gold star type of appointment. In this particular type of agency, the seller has to pay the agent's commission whether or not the agent is the effective cause of sale. If that property is sold, you will pay that agent commission, and that is why they love this stuff. If another exclusive agent is appointed, which does happen, unfortunately, as I said, sellers often get confused about the nature of these types of appointment. Then the seller's going to be in breach of their exclusive appointments, and they will likely have to pay 2 lots of commission if the house is sold. So these things are not to be trifled with, and I guess this is one reason to get independent legal advice when you are filling out that Form 6 appointing an agent. But as I said, I don't know of many people that do so. Maximum term here again 90 days. And again, cancelling isn't as easy as for an open listing. If the appointment is more than 60 days, again, either can terminate on 30 days written notice, again, has to be on foot for 60 days. And if not terminated, it will expire at the 90-day mark as for sole agencies. You can't roll over the agency into another 90-day term and just keep rolling it over under the one Form 6. You can stay, and this is what a lot of agents do, you can stipulate that at the 90-day mark, the agency will revert to an open listing, and that's one way for the agent to keep their clause on the property at the 90-day mark, and then hopefully entice you into another 90 days if in fact they haven't sold the property. But you can't have one Form 6 that appoints the agent for rolling terms of 90 days. It can roll into an open listing, but from there, if you want to negotiate another exclusive agency, you'll have to fill out another Form 6. EBFEST is the case that we talked about before, that the seller complained that they didn't get properly briefed on all of these different types of agency. It was found, as I said, that the agent had done the right thing, but nevertheless, money wasted, wasn't it? The next issue is, who is the effective cause of sale? And this issue normally crops up where the agent has their hand out, please pay me my commission, thank you very much, and the seller is usually the one saying, yeah, sorry, I don't think you were the effective cause of sale. Usually more than mere introduction is required. Usually you will have to get the contract over the line and sale completed, actual settlement. However, if it's the case that the agent has arranged one contract and then through neither the agent's or the seller's fault, that contract falls through, and the exact same parties get together and then collude and complete a sale that way, the agent may well be involved, and that was exactly what happened in Anderson and Densley. In that case, the agent actually would have been entitled to commission, but because of a technicality, that good old appointment of agent wasn't valid, so there was insufficient evidence of the appointment in writing, then they lost their opportunity at obtaining the commission there. Sometimes this kind of thing will crop up where there has been a buyer and seller entering a contract and then finance falls through, and then there's some kind of intervention by another agent, and then the same buyer and seller get together, the finance works the second time, and then there's a dispute about whether agent A or agent B or both is due to be paid commission. In Wyatt and Ball, they held that the agent B, the second agent, was the effective cause of sale because the agent had actually suggested the way in which the finance should be applied for the second time round, which was successful, and so agent A missed out. Similar kind of circumstances in the Rasmussen case, and in that case the court held that to be the effective cause of sale requires not merely finding a buyer, but that the contract had been entered and the sale completed, settlement gone through. The text also looks at the issue of loss of entitlement to commission, naughty things that the agent might have done to lose themselves the commission. It also looks at the seller's naughty attempts to avoid commission. We don't need to go into them here, but make sure that you're across those. The other thing that we need to be thinking about when we're talking about agencies, particularly in southeast Queensland, this can be a problem, is where there is an agent in one jurisdiction that purports to sell property in the other jurisdiction. And that's exactly what we had happening in the Sultana Investments case. In that case, we had a property in Queensland, although the agent was located in New South Wales. The contracts were drafted, signed and completed up here in Queensland. The buyers were flown to Queensland for their inspections. It was held that the agent unfortunately couldn't get his hands on commission there. The agent needed to be licensed in Queensland to claim the commission. There was sufficient nexus in the deal to require a Queensland licence. So tips for young players: if you're going to conduct that kind of a business which straddles the border, you need to make sure that you are appropriately licensed, otherwise you may well miss out. That is appointment. Okay, so the next thing to look at is duties. And once you've got your valid appointment squared away, it will give rise to various duties at law under the Property Occupations Regulation and under the ACL. If you don't comply and do the right thing, then obviously as an agent there will be trouble, trouble, trouble. Damages for breach, possibly an account of profits for any secret commissions you've made, and good old loss of commission, that old chestnut. So the first duty is to go ahead and perform the contract of agency as it is stipulated. And there you will see in Regulation 22, a property agent has to act in accordance with the client's instructions. Sounds basic, but there you have it. So you mustn't market or otherwise advertise for sale, purchase, exchange, blah, 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 at a price or on terms different from those authorised by the client. If you don't act in accordance with your client's instructions, obviously you're going to be in breach of the agency agreement. If you have to get a variation as an agent, best advice is to the agent, go ahead and get the variation, because if they step out and do something outside the instructions, they're going to be in trouble. The second is the duty of care and skill. You should be familiar with this one because it's imposed under the ACL as well as at law. And just in case you need reminding, Section 60 of the ACL says that if a person supplies in trade or commerce, there's that magical phrase in trade or commerce, services to a consumer, there's a guarantee that the services will be rendered with due care and skill. Catchphrases, got to be a consumer, which means that obviously the procurement has to be for less than $40,000, or it has to be for personal, domestic, or household use, which, you know, selling your personal residence will likely be caught. As to skill, you need to have the appropriate educational qualifications, and obviously you've got to be licensed appropriately. If those things are no good and not satisfied, then obviously you can terminate the agreement there. The standard for skill is the same under the ACL and at law, so you've got to have a workmanlike manner and reasonable skill and ability, okay? You don't have to be exceptional, you just have to be reasonable as a real estate agent. Obviously, you can't sue the agent under the ACL just because they don't get your list price for you. Okay, there's no guarantee of the result here. There is a guarantee that the agent will do a reasonable effort in terms of getting the price that you've asked for. If there's a failure here, obviously, as I said, there can be a breach of an implied term of your agency agreement. The agent can be up for disciplinary proceedings if they are found to be wanting in care and skill. And under the ACL, there is possible, as I said up there, termination and or compensation. So that's your duty of care and skill. Good faith, well, this is something that I think most people would like to think that most professionals would have some idea about, although, you know, there you go, it needs to be spelt out. I won't belabor these because we went into conflicts and so on in a fair amount of detail last week, but the three big ones here in similarity to last week are the duty to ensure that the interests of the client are not in conflict with the agent's interests, the duty not to make any secret profits from the relationship, and here we have the good old kickbacks that sometimes happen, for example, where a real estate agent refers a seller on to get some work done on the property, or refers the buyer to a particular additional service provider from which they are getting kickbacks. That's a naughty no-no. And if that's happening, well, you've got a breach of your duty of good faith, and obviously confidentiality is another one there. So that's good faith. The text at around page 63 goes through those. In terms of what authority the agent will have once they're validly appointed, pretty basic. They can describe the property sufficiently to identify it, describe its location, the asking price, but they have only limited authority to make representations. Often they will make representations, and a lot of it will be puff. However, that can get them into some problems, and we'll look at misleading or deceptive conduct shortly. They have no, this is important, they have no implied authority to bind the seller contractually. So unlike a solicitor that may in fact alter the course of their client's destiny, so to speak, the agent has no authority to bind the seller there. Their ostensible authority doesn't extend to that should be entered into a contractual relationship on behalf of the seller. So that's the agent's authority. And I think we have gone past the 15-minute mark, so I will cut this video off here and I will see you all in video 2. Bye guys.